The inside story on the issues that affect you and your community. This is Local 12 Newsmakers.
Your leadership on this, is changing the country.
I really appreciate that, Mr. President. It's really been an honor for me to be involved in this fight and to have been able to, fight for my marriage and live up to my commitments to my husband.
A Supreme Court ruling on June 26 that changed the country has local roots. Good morning and welcome to Local 12 Newsmakers. I'm Dan Hurley. The coverage around Supreme Court decisions often seems theoretical and abstract, but in our system of law, behind every abstraction stands the concrete circumstances of individual lives. The lead case that transformed the legal standing of millions of gay men and lesbian women will forever be cited by the Cincinnatian's name, James Obergefell. That case was filed by a local law firm of Gehardstein and Branch and was bundled with 5 other cases that reflected a variety of specific concerns of men and women who found themselves caught in the legal web of state laws which their marriages were recognized in some states but not in others. To discuss the local and human implications of the Supreme Court ruling, I am joined this morning by Al Gerhardstein. His firm, Gehardstein and Branch, states its mission is using the law to help people on the margins who are victims of discrimination, mistreatment, or violence by those abusing corporate and or government power. Mr. Gerhardstein filed the case of Obergefell and Hodges on July 19th, 2013. That turned out to be the lead case that reached the Supreme Court. I was joined this morning by Kelly McCracken, and she and her spouse, Kelly No, who we had hoped was going to be here, were part of this legal decision as well. We were also hoping for their daughter Ruby, who is 13 months. Ruby had a difficult night, and so she's not here, nor is Kelly, the other Kelly. So both of you, welcome to Newsmakers. It's really good to hear you.
Good morning. Good to see you.
Al, probably about a year and a half ago, you were on here sort of after the circuit court decision. And we were talking about this, and I posed the question to you, well, why not just take this on head on? Why not, given change in public opinion, why not just go for a statewide referendum? Let's just take care of this. And you said, well, we're Midwestern, we take it one step at a time. Plus, legally, we need to work our way through the courts. And this then turned into the case that was going to overturn everything. When did you have a sense that your cases might actually be the ones that go to the Supreme Court? Because there were a lot of cases around the country.
There were, and we saw decision after decision, more than 20 district courts across the country, all ruling in favor of same-sex couples being able to marry and also to have their marriages recognized. And these were happening as we, worked our way up through the courts. Generally in circuits that were a little more liberal than the Sixth Circuit where we are. And we saw that this was really going much faster than we had envisioned. And then when the Supreme Court decided not to accept any of those cases for review because there wasn't yet a split in the circuits, we started feeling that ours might be the case.
And just to be clear, the Supreme Court does not have to take every case. It chooses which cases, and one of its roles is to wait until the different circuits are handing down different opinions, and that's when it usually steps in.
Yes, there are 2 criteria for Supreme Court review. One is if it's a matter of huge public importance, and the other is if there's a split in the circuits. This is obviously a matter of huge public importance, but they chose not to act early, and that actually allowed up to 37 states to open their doors to marriage for same-sex couples. And that was a part of the dynamic that we were dealing with. And then, of course, our case came up as part of all the cases from Michigan, from Tennessee, and from Kentucky as a consolidated set of appeals, and we lost.
Okay. Kelly, when did you decide you and Kelly decide you wanted to get involved in the legal process? Was it when you got married and you, because I have I have friends who got married in Massachusetts just like you, and they just decided not to come back to Ohio. They're in New York City. So that was their way of dealing with this. Was it the marriage, or was it when you knew that you wanted a child and it was the child that sort of triggered it? Because in your case, it was a birth certificate. In Jim's case, it was a death certificate.
Correct.
That was so these specific differences. But when did you decide you want to get involved legally?
We call ourselves accidental activists. It was when Ruby was born that we went into Al's office and, said, what paperwork do we need? I know that our marriage is not recognized. I know it may be a struggle to get us both on the birth certificate. Is there any way around it? What are we going to need to do? Because when we were married in 2011 in Provincetown, Massachusetts, we came back to Ohio. We knew that it wasn't recognized in Ohio, but to us, we were married. And, that was good enough for us. We love each other. That was good enough for us. And, I remember saying, maybe once in our lifetime it'll be recognized, and but for now, we're married. But yeah, when Ruby came, it became something legal. We were nervous about her rights and what are my rights going to be as her mother. So that prompted us to seek some legal help.
And actually, it was right before Ruby came, because you were...
That's what I was going to
ask.
Definitely
That's what created
before.
the emergency, because there were 3 couples, 2 others in addition to the Kellys, that all were about to give birth, and they didn't want to start the life of their child with only one person recognized as the parent on the birth certificate, and that's a big deal. I mean, you want to have 2 parents. Life is hard enough. And you really want to have all the legal protection you can have, all the social support you can have. And for same-sex couples who are married, they just were treated totally differently than different-sex couples who give birth, and that's what helped us frame that end of the life spectrum as part of the lawsuit.
So, 2 quick questions for you, Kelly. How did you find Al? Did somebody say, oh, those are the kind of questions you got? You need to go to Al Gerhardstein because he deals with these kinds of civil rights issues. How did you find him? And secondly, I lost the second question. So how did you find Al?
Yeah, a friend recommended Lisa Meeks, who is also in the same...
co-counsel.
Co-counsel, yes. Yeah. And we just kind of fell into...
And then when you had that first meeting, what did they tell you? You wanted to find out, was there anything you could do on the birth certificate that was coming up? What was the immediate response?
We have a couple other couples that are in your same boat. Would you like to join on to this legal suit? And we said, absolutely. Because
in the short term, there was nothing that you could do to get both your names on.
I would have had to carry around a stack of papers, and who knows if, I have to take Ruby to the hospital, God forbid, the person reading these papers is even going to understand what they are.
Right.
But yeah, it would have had to be all kinds of
Speaking
hoops.
of that, legal terms, legal language, Al, what in layman's terms did the court really say about marriage?
The Supreme Court?
Yeah. What did it say about the institution of marriage?
Well, actually, it was remarkable. What the court said was that marriage is the fundamental institution in our society, around which all of our social structure is based, that marriage is bilateral, that it's always had this 2-partner notion to it. Secondly, that marriage is something that we're owed as a matter of personal choice and liberty, which is very important, and it recognized that marriage is inherent in our liberty and in our dignity as citizens of the United States. Thirdly, that marriage is should be available on an equal basis under the Equal Protection Clause, just like loving couples who are different sex. So those are 3 of the things that the court said about marriage, and as a bundle, the court was saying that there just is no notion that supports discrimination against those who are of the same sex. And it went on to say, there's a lot of people out there who say that marriage has historically been between a man and a woman. And those people say we shouldn't change it. Well, the court wisely said, you know, there's been a lot of other historical aspects of marriage as well, like coverture, where the woman melted legally into the man as part of marriage, or domestic violence, which was tolerated and where you couldn't even be prosecuted for rape of your wife. And all of those things are gone now as we get a better enlightened view of our liberty as individuals in marriage. And so the court was quite willing to recognize that these same fundamental principles of equal protection and due process support extending marriage to same-sex couples.
And I think the opinion also cites Loving versus Virginia in
Oh,
67,
absolutely.
that there are, which recognize the right of interracial marriage.
Right.
But there's lots of social changes over time.
Absolutely, and it's so interesting. We used Loving as one of our anchors for the whole litigation. And at the time Loving was decided in 67, there were 16 states still that prohibited interracial marriage, just like there were 15 states when we went to the Supreme Court in April that still prohibited same-sex couples from marrying. So there are a lot of parallels there.
Kelly, when the case went to the Sixth Circuit here that sits here in Cincinnati, did you go into that mentally? Did you go into that process thinking, oh, they're going to rule for us, and this is going to take care of us, because all these other decisions around the country? And were you prepared psychologically for the ruling that came out? It was like, we got to keep going with this.
Pretty much, yes. We were hopeful, but at the same time, you know, kind of standing guard just in case. I think we were a little more hopeful then, and then to be let down with it getting appealed. So then that way, going into the Supreme Court, the whole time I was like, oh, you just don't know, you can't be sure. So that's why it was, you know, even a bigger surprise. Yeah, we were guarded the entire time. Right, because we kind of got up pretty high at the Sixth Circuit because all these other states around us are going through with it, so.
But even Ruby could tell that we were having trouble in the Sixth Circuit. Ruby was at the argument at 3 months old, and you know, it was a tough argument. We knew we had a
in the midst of the argument, even before the.
Oh, absolutely. This is tough. Yeah.
One last question for this part of the show, and then you're going to stay with me. This is the second part, but. Al, you do a lot of this kind of work, this civil rights work, and it takes a long time. You got to be patient. Actually, in some ways, this went really quick.
This was quick.
Compared to a lot of the cases that you've had. Real practical question. How do you get paid? How do you make a living? Because I suspect the people you're representing are pretty ordinary people, and they're not necessarily just got deep pockets. So
we take all of these cases on a complete contingency. There's something called the Civil Rights Attorneys Fees Act. And if we prevail, we can apply to the state, apply to the court to have the state pay us because we did have the law struck down as unconstitutional. So it's a high stakes game. I mean, when we lost the Issue 3 case, we lost and we didn't get paid. When we won this one, we'll be applying for fees.
Do you apply to the U.S. Supreme Court?
We'll be applying to the district court.
To the district court,
right.
Okay, but
right.
It's a federal.
Yeah, it's a federal law that we're relying on, and then we'll ask the state to pay.
Okay, we're going to take a quick break, and then we're going to come back, and we're going to take a look at sort of the aftermath of this and what still needs to be done, what still needs to be talked about. Stay tuned. After a brief break, we'll all return. Last Sunday, the Pride Parade in Cincinnati was especially energized, and the star was Jim Obergefell, whose case helped change the law on the place of gay and lesbian men and women in American society. And Al, help me say his name correctly.
Obergefell.
Right.
Okay. Blah. My mouth just sort of freezes up. Welcome back. This morning we are exploring the implications and the human side of the Supreme Court ruling 10 days ago on the rights of gay and lesbian couples to enjoy the full benefits of marriage in all states of the Union. I am joined this morning by attorney Al Gerhardstein and Kelly McCracken. We do not have Kelly's partner, spouse, Kelly No, who is not able to be here this morning. I want to although the Supreme Court has settled many issues, others remain. Here's part of a report filed by Local 12 reporter Anjanette Levy about the equal rights of same-sex couples when it comes to children and the validity of birth certificates.
They're excited both of their names will appear on their baby's birth certificate. One of the cases the Supreme Court heard dealt with married same-sex couples who wanted both parents' names on their child's birth certificate.
I mean, on multiple levels, if something were to happen medically, and Ryan's out of town, I can make sure that that's taken care of by being on the birth certificate.
That birth certificate is only evidence of parentage and is open to an attack.
Ellen Essig was co-counsel in the case that dealt with same-sex couples and birth certificates. She says the birth certificate is not foolproof when it comes to ensuring parental rights.
There is still the question of the security of that piece of paper, the birth certificate. I am recommending to my clients that they get a court order of parentage as well, because that court order will be secure no matter where they travel to.
Okay, welcome back. On that note, both of you, since this is the specific issue that you're concerned about, Kelly and Al, from a legal point of view, what's your understanding of your name will now be able to stay on Ruby's birth certificate? Is that sufficient?
Well, Ellen's right. You know, the bulletproof way to do this is to have a court order that's unique to your parenting situation. But for almost all purposes, for many purposes, simply having both names on the birth certificate will be good enough. So some of it's about your economic, capacity. How many people have the money to go get a lawyer and do this? And some of it's just your risk tolerance. If both names are on the birth certificate, you can get a lot done. What we've achieved in this case is that same-sex married couples will be treated the same as different-sex married couples. That's our core principle that we've achieved. Beyond that, there are other legal issues that will come up, but those would also come up for different-sex couples.
What are you and Kelly thinking that you want to do in this situation? You
put the birth certificate in a frame and hang it on the wall.
There you go.
Pretty much.
And we are going to get the asterisk off her birth certificate.
That's
right
all we
now,
want.
Ruby's birth certificate has an asterisk that says pursuant to court order, and that's coming off.
Okay, all right. There are other legal issues that I've seen in articles that have been cited. What about clarifying benefits for same-sex married couples that are, the question of companies that maybe have been paying partner benefits on the argument, though, that now same-sex partners can get married. Can they then say you must get married before you have partner benefits?
Well, some of that's going to be by virtue of contract, whatever the pension contract says. We haven't solved all these problems with the Supreme Court ruling. We've simply set a framework for saying they ought to be treated the same as different-sex couples. So sure, there's plenty of work for lawyers to do. There'll always be work for lawyers.
I was worried about you.
Yeah, no, we'll be fine. And I think for the most part, our goal will be to achieve parity. Okay. And that's what we're seeking.
One of the other areas that has gotten a lot of discussion, a lot of turmoil behind it, is the question of what this ruling says about church and state. And people are saying, oh, this is telling churches and ministers what they must do.
That is totally bogus, and it is completely generated in order to create fear among people. There's, on page 27 of the court's decision, it specifically says, Justice Kennedy says, that we are not going to be forcing ministers to perform these weddings. That if you have a sincerely held religious belief, the First Amendment protects you from being forced to preside at a wedding. End of story. Mm-hmm. I don't think this is a problem. The real problem is that there are many states, including Ohio, that will not protect the Kellys from discrimination in employment, from discrimination in public accommodations, from discrimination in housing. If we want a problem to work on, that's something we can work on. They can get married, but they can't hold a job. They could be fired for showing their wedding pictures off at work. So we still have plenty of work to do that's real work.
Why? Is it just that they're not protected? Or?
Right. So our Civil Rights Act
Right.
Protects in private settings. So the way this works is we've achieved a great deal under the Due Process Clause and the Equal Protection Clause against the government, marriage, and government employment. But private employers are free to discriminate unless our Civil Rights Act says that's a protected status. Race, sex, national origin, religion are protected statuses. Sexual orientation is not.
Okay. All right.
So they can be discriminated against.
Kelly,
and I don't know if that's been a problem, but
not
it can
for me
be.
personally, but it definitely can be,
Yeah.
of course.
Kelly, outside the legal realm, I mean, this has thrown you and Kelly into the spotlight. What's been the reaction by family, by acquaintances, close friends? I'm sure I can suspect what their feelings are. But what's been the reaction to all of this? And not just the decision, but this whole process of going through these various levels of the court.
From the beginning, it's been so much love and support from friends from my high school, from Kelly's high school. All 98% of our family is right there behind us. It's been nothing but love and support, just ongoing from the very beginning, and it just has built and built as we went further through it.
So, and even after this decision, do you receive any, because of the reactions in some places, and news can sometimes go out and seek out people who are going to say crazy things, and nasty things. But on a personal level, has that come to you, or is that just not part?
It hasn't. On a personal level, no. Strangers are coming up to us and saying thank you. You know, couples that have been together for years and years can now get married in their home state, and they're thanking us. And I mean, it's overwhelming. But no, I do see a lot of the negativity coming out, but I got to turn the other cheek. There's just too much good in my life that I'm focusing on to let any of that get me down. So yeah, we try and just look the other way.
Hard to believe this is Cincinnati, right?
Right.
I mean, we were around 93 when the Human Rights Ordinance is repealed. We have issue 3. I sued to get it repealed. The judge says it's unconstitutional. The hate and the concern of people who opposed us was palpable and strong. And yes, it's a new day. Yeah. It is a new day, and it's wonderful that it's grounded here in Cincinnati.
Well, you know, the hate is still palpable and strong some places in this country, with probate courts refusing to issue licenses to same-sex couples, or maybe refusing to issue license to anybody as a way of just avoiding this whole thing.
Right, but that's a minority.
Temporary?
I think so, and it's a minority. I mean,
it'll take some time.
I think you're right, Kelly, and also I think it's wonderful that courts like Judge Winkler, a Republican, was quick to say, all right, I'm going to follow the law. And right on decision day, we had couples getting married right here in Cincinnati with our own mayor presiding. That's great stuff. That's wonderful.
I saw the mayor at a function at about 5:30 that evening, or 6 o'clock, whatever it was, and you know, he was just beaming. I mean, because he had gotten to do that, because it was, I think his opening words, which so many people said that day, "What a day!"
Yeah.
You know. So, Kelly, I want to end with you, and that is, because of all of this, and it's a whole big ball of stuff here. It's not just the court decision. How is Ruby's, your infant daughter's America, going to be different than yours?
She's going to grow up knowing she has legally 2 parents. She already knows we love her. She has to. But she's not going to grow up in a world where she feels like she's different. And that's what we wanted. I don't want her to feel like she's an outcast or different because she has 2 moms and not 2 dads, or a mom and a dad. We're a family. We love her. She's not going to see all the hate, hopefully, as much as we can shield from her. It's just tremendous that she's going to know that this was a turning point in our country, and it happened when she was young, and we can tell her about it as she grows up.
And she was part of it.
She was totally a part of it.
Yeah, that's pretty neat. So, Both of you. Al, thank you for all the work you do, and there's many other fields we could have talked about this morning. And Kelly, thank you for being here and sharing your story. And good luck as things move forward. Thank you for making Newsmakers a part of your Sunday morning. Join us again next week to meet the women and the men working to make a better region for the future. Have a good week.